चाहिए? रख दो रख
The partner in the course of marriage is the basic tenet of marriages in Indica. In Indica, prostitution took its form in ancient times. Subsequently, the Immoral Traffic Prevention Act 1956 was the main legislation drafted in the view of trafficking and solicitation of women in India. There have been a constant demand from the class of sex workers to legalize prostitution in Indica. In 2020, the Liberal Party won the general elections and enacted the act. The new legislation has legalized commercial sex due to the enactment, because of which there is a dip in the number of cases of sexual assault from the past 3 months. Public outrage, as it states, the fundamentals of marriages in India and is opposed to the moral values shared by the Indican society. Many single women are freely practicing this profession. A civil society organization named Astitva has challenged the constitutional validity of the Indica Commercial Sex Workers Protection and Regulation Act 2021 before the Honorable Supreme Court of Indica. The Supreme Court admitted the petition. An NGO named Tree of Life, representing the commercial sex workers, filed an intervening petition. The petitioners have approached the Honorable Supreme Court under Article 32 of the Constitution of Indica. If your lordships are satisfied with the facts of the case, the council seeks permission to proceed with issue 1. Much obliged. Your lordships, issue 1, whether Section 3 of the Indica Commercial Sex Workers Protection and Regulation Act 2021 is violative of right to privacy. Your Lordship, the Council, appearing on behalf of the petitioners, humbly submits before this Honorable Supreme Court that it is violative of the right to privacy. Section 3, Chapter 2, which is in Chapter 2 of the Indica Commercial Sex Workers Protection and Regulation Act 2021 is violative of Article 14 and 21 of the Constitution of Indica. As stated in the facts, Para 2, last line on page number 1, Your Lordship. The law has been passed to prevent rampant criminality and to promote the welfare and health of sex workers. This particular act is formulated on the demand of the class of sex workers. However, it composes an unreasonable restriction upon them. To be precise, Section 3 and Chapter 2 of the Indica Commercial Sex Workers Protection and Regulation Act 2021 deals with registration of commercial sex workers. According to the Act, a sex worker has to register himself by making an application to the district magistrate along with the prescribed fees in order to freely practice commercial sex as a profession. The Act claims to regularize prostitution in Indica. However, Your Lordship, on the other hand, the Act has imposed unreasonable restriction. In order to obtain the license, the sex worker has to fulfill and comply with the provisions prescribed in Section 3, Subclause 1 of the Act. Your Lordship, I would like to draw your attention towards the same. Your Lordship, Section 3, Subclause 1 deals with registration of commercial sex workers. However, Section 3, Subclause 1, pointer number 1, 2, and 3, which demand the name of the commercial sex worker and manager, if any, the postal address of the commercial sex worker, and the proof of age and declaration. Your Lordship, all of this information is very personal of the commercial sex worker and is demanded and not that of the person. In the present act, only the information of the commercial sex worker is demanded and not that of the person who avails such services from them. As the act ensures to be in the interest of the sex workers and claims to provide security to them, then the person who avails such services from them, why is their data not demanded? This is direct infringement of their right to privacy. Your Lordship, the Act fails to stand by its actual motive. Only collecting the details of the sex workers will not ensure their safety and security. In regards to if the sex workers face any issue during the time of practicing the profession, then how will the person, especially the special investigation officer who has been appointed, how will he get the information of the person who avails such services? If it is collected, it will help in better investigation. Your Lordship, this is not where it gets restricted to. However, the entire Act is absolutely silent on how the data will be collected and protected by the district magistrate. There is no provision in the Act that specifically talks about that the data that is going to be collected, how is it going to be managed? How does a district magistrate ensure the sex workers the right that the data that they are providing to them would be ensured and safeguarded? Your Lordship, the Act is absolutely silent and neglects a very important and crucial topic, which is the personal details and the confidentiality of the information that is being demanded. However, Your Lordship, I would like to draw your, this is not again restricted to the management. However, Section 3, Subclause 3 of the Act clearly states that the information entered into the register of the commercial sex worker shall be made available on an application and payment of prescribed fees. Your Lordship, first of all, there is no management of the data. There is no guarantee of how they're going to protect the data. However, they have come up with a provision which clearly states that by making a mere application to the district magistrate and paying the prescribed fees, the information, the confidential information of the sex worker is going to be provided. This is basic infringement and direct infringement to the rights of the sex workers, Your Lordship. Moving to Section 3, Subclause 1, pointer number 5, that talks about medical examination. Your Lordship, the sex worker needs to, during the time of registering himself for the license, has to undergo a medical examination. However, this medical examination is only done on the part of the sex worker and not of the person who avails the services from them. If they talk about the sex workers over here and they say, and they conclude to the point that the sex worker, in order to ensure his safety, they are ensuring that he should undergo the medical examination. However, to ensure that he is free from any chronic illness or diseases or infirmity. However, this provision ensures that the person who avails such services from the sex worker is not affected by any sexually transmitted diseases. However, sexually transmitted diseases by the person availing such services is completely taken for a toss and is completely neglected. The sex worker's health and safety should be given prime importance and should be prioritized. The Act, however, stands silent in ensuring the health and safety of the sex workers. The Act has given importance to the health of people at large, that is the public, and somewhere completely neglected the welfare and health of the sex workers. This is again a very direct infringement to the right of life and personal liberty guaranteed under Article 21 of the Constitution.
Before this, what you have argued now, on subsection 3 of section 3, you have said that there is no mechanism to keep the data in confidence. If to that extent, if we read it down, whether you are satisfied with that, we'll read it down, that subsection, or ask the parliament to make amendment so that instead of making available the data to the public, let them keep in confidence. What do you say on that?
Your Lordship, the petitioners who are approached, the council that is here on the behalf of the petitioners has the basic contention that first of all, there is no management of the data. The data that is going to be collected is that this needs to be understood that this is of prime importance.
No.
And the data.
No, I am saying the same. We are saying the same thing. We'll direct the state to keep the data in confidence in consonance with the Puttaswamy judgment. Let them keep data in confidence.
Indeed, Your Lordship.
Merely because that one clause or one word saying that you make an application, data is available. We cannot struck down the entire law, no?
Your Lordship, coming to this point and addressing the question that is raised by you, this is not the only provision that we are objecting. There is going to be several other objections in regards to the Act, and that my co-counsel will be dealing with under issue 2 and 3.
Unless the information is collected from the applicant who is seeking for the license or whatever, then how the license has to be issued? There is a rationale behind that. Unless a particular identity of a person is required, no? But whether that identity can be made in a public or not is another issue.
Your Lordship, the
But
issue...
you can't say that you can't collect the information from the particulars like name, address, postal address, unless that is there. There is a likely to misuse also, no? There is a rationale behind that. What do you wanted to say on that?
Indeed, Your Lordship, the issue is not only restricted to the demand of the information. It is restricted, it is the main contention that the petitioner, the council appearing on behalf of the petitioner is trying to make is that there is no management. How they are going to provide security and safeguard the rights of the sex workers. We are not objecting only the demand of the information, but we object the management, how they are going to manage the data, how they are going to collect the data, and if anything, any mismanagement of the data or the data is leaked, then what steps, what precautionary steps are they going to take on their part? And the Act is absolutely silent on it.
But Council, the information which you are seeking and relying upon can be put in form of regulations framed under the Act? Have you seen the regulations? Are there any regulations under the Act?
Your Lordship, talking about the regulations of the Act, the Council would again submit the same contention, saying that we do not only oppose a certain section, as issue 1 is only restricted to the right to privacy, and the section 3, we are not only restricted to it, we are going to be, in the further issues, we are going to raise further more contentions that we oppose in the Act, and that is how we want the Act to be struck down entirely and to be declared unconstitutional.
The whole section 3 or part of it, because it has 5 clauses.
Your Lordship, as I rightly pointed out, that again in section 3, subclause 1 and the further pointers in that, that is also something that is being raised by the petitioners. If you're to proceed with the further argument. It is thus the fundamental duty of the sovereign to protect the safety and security of every citizen. The facts are also very evident as there is registration of fake licenses as well. As these drawbacks thus result into the unreasonable and biased and fails to provide benefit to the sex workers at large. Thus, from the above contentions, it is humbly submitted before this Honorable Supreme Court of Indica that the data demanded by the district magistrate to issue license to practice commercial sex as a profession is violative of the fundamental rights guaranteed under Part 3 and Section 3 of the Indica Commercial Sex Workers Protection and Regulation Act 2021. And it is violative of right to privacy in the same. If your lordships are satisfied with issue 1, the council would like to call upon the co-council to deal with the further issues. Much obliged.
See, if you just look at Section 3 in the light of Article 21, which you are relying upon, that allows the legislature to put restrictions on the rights, fundamental rights, including right to privacy, if that procedure is not capricious. And how do you presume that this procedure which you are talking about is going to be capricious or oppressive?
Your Lordship, when we raise issue under Section 3 and the various subclauses, we again demand that this Act lacks clarity. The Act is lacking the provision that needs to be put up. And because this Act talks about the welfare of the sex workers, then this is somehow putting an unreasonable restriction upon them. And this needs to be, clarified, and this needs to be put up in such a way that it ends up giving them benefit instead of just violating their fundamental rights, which shouldn't be infringed.
Striking down the act should be on a certain grounds. Which are the grounds? Supreme Court can strike down the legislation made by the Parliament merely because it is a confusing, it is not understood to you. That is a ground.
Again,
on what grounds the parliamentary legislation can be struck down?
Your Lordship, if it is against the Your Lordship, if the restrictions which is imposed on the certain section of the society, if it is unreasonable, it can be. And if it is against the public, if it is violating the fundamental rights of the citizens, and if it is against the public health and morality, then it can be.
Challenging the Parliament's right to make such kind of enactment? Does it fall within its jurisdiction to make a law on sexual matters? Are you challenging its jurisdiction?
Indeed not, Your Lordship.
Then what is your challenge then?
The basic contention behind the same is that the act, the present act and the sections which is being implemented in the present act is violative, and the council is only opposing the same.
Madam Counsel, if you go by the title of the act, it talks about regulation. It doesn't criminalize. It only it regulates.
Indeed, Your Lordship.
Prostitution is regulated, not criminalized. So regulation is permissible, and that falls within the jurisdiction of Parliament on the grounds of health, morality, or any other grounds which you find in Article 19(2) of the Constitution of Indica.
Your Lordship, as the council clearly mentioned earlier also, that we only do not objectify the present section of the act, but several other contentions as well, which will be dealt further by my co-counsel in issue 2 and 3. If Your Lordships are satisfied, the council would like to call upon the co-counsel. Much obliged.
Your Lordship, the second issue that we deal at hand states whether consent is violative of marital sanctity. Your Lordship, what we mean by that is by stating that Indica, in the fact sheet as well, it has been stated that, that marriage is a sacrament. It is one of the most vital factors that Indica has. It also states that marriage implies that one's partner has to be committed to another. Your Lordship, now when we state that for a sex worker to practice commercial sex, he has to seek the consent of his spouse. We fail to recognize that such spouse whose consent has been sought can also be coerced. Your Lordship, further, when we state that any person in a marital relationship when goes ahead and indulges in such occupation, it cannot be held that the marital sanctity will be intact. Your Lordship, there will be some strain such act will impose. Your Lordship, it will not protect something that Indica has tried for years. Your Lordship, to further my contentions, The council would like to argue that consent in the court has held that spousal consent in many cases cannot be considered to be violative of fundamental right. Your Lordship, to shed light on the same aspect, council will draw your attention.
Before you proceed further, the court has one question for you. This act is gender neutral.
Indeed, Your Lordship.
Why do you presuming that husbands are going to coerce their wives to enter into commercial sex? It could be other way also. Then how do you respond? And this is premature because Act is of 2021 and we are now 2022, 23. Do you have any statistics to substantiate your argument that husbands have coerced their wives to enter into commercial sex and thereby you want to assail the Section 3?
Indeed. Your Lordship, to answer your query, the council would again point towards page 2 of the proposition itself, which mentions that the women are subjected to domestic violence and mental cruelty, and they are harassed for giving consent by their husbands. Your Lordship, the intent behind stating that the consent in the present case can also be coerced or forced, or either spouses, Your Lordship, even if we consider we consider the act as gender neutral, either spouses are able to coerce the consent out of the other spouse, Your Lordships. The act makes no such provision which states that such consent, if obtained involuntarily, can be penalized, Your Lordships. Your Lordships, to further state, the council would like to draw the court.
Sorry to interrupt this one. I think you are arguing on some presuppositions. Presupposition is that husbands are going to coerce their wives. There's a presupposition, and no act can be declared unconstitutional merely on presuppositions, unless until you have got substantive information to attack on the section or the whole act.
Indeed. Your Lordships, further to shed light on the same issue, that is spousal consent, council would just like to reiterate the court's attention to a case where surrogacy was concerned. Your Lordship, when surrogacy came, initially a bill was passed. Now, the bill for commercial surrogacy stated that the woman could indulge in commercial surrogacy, that she could lend her womb. Your Lordships, the legislature had considered the aspect and had held that there could be cases where the husband forces his wife to undergo commercial surrogacy, and the part of the wife, it would constitute cruelty. Your Lordship, thus the Commercial Surrogacy Act was not passed, Your Lordships. The court had considered this contention. Your Lordship, to further substantiate the same, Your Lordships, in the case, if Your Lordships refer to page 17 of the petitioner's memorial, Your Lordship, this is the case of a Madras High Court that the council seeks to cite. It is merely for persuasive effect, Your Lordships. It is not a binding precedent, but the council just wants to shed some light. In the case of Dhanan Shezia versus the state, Your Lordship, the case had a conundrum within itself. Now, what had happened in the case was the husband and wife in the relationship the husband had sought the help of an extramarital affair. He had indulged in some sexual activity with the prostitute. Your Lordships, however, what the husband did do, he obtained the consent of his wife. He stated that he led his wife to consent to his extramarital affair, and the wife later committed suicide. Your Lordship, the intent behind spousal consent, stating that it would violate the sanctity, it will ensure that such incidents will happen rampantly. It would give free rein to husbands or even either spouses to practice or force their spouses into commercial sex work, Your Lordships. Your Lordships, further, the Delhi High Court. Your Lordship, again the council seeks citing a Delhi High Court judgment just to draw your attention, Your Lordships, in the case of Vineha Devi versus Government NCT of Delhi. Your Lordships, if you refer to page 18 of the petitioner's memorial, point 7. The insistence on spousal consent being obtained clearly ultravies the provisions of the Transplantation of Human Organs and Tissues Act. Your Lordship, the further judgment also deals with another crucial aspect, being insistence on such a requirement would also impinge upon the right of the petitioner to be in control of her own body. Your Lordship, in the instant case, if the act indeed benefits the sex worker, it also imposes a restriction on them. It states that the sex worker can practice his profession only if his spouse consents to it. Your Lordship, this is an unreasonable restriction that has in place on the right to practice his own profession, his or her profession, Your Lordships.
those judgments are in the context of when one spouse is wanted to have intercourse with another spouse. That has come. Here is altogether a different case. You can't compare that with this case. This is here, either husband or the wife wanted to have relation with a third person. At that time, whether consent is there or not, how it's strictly legislation, Parliament wanted to regulate that. It is not that absolutely. And if it is consent is obtained by fraud, this law may not have a mechanism, but other legislations are there where you can approach and say that this is fraudulently consent has been obtained, and prosecute him under the penal legislations. This is not the only legislation which it may not be having a mechanism, but other laws are there. You can make use of that. And instances, there is no cause of action as for you to challenge this legislation. Where is the cause of action? Where such instances data is available?
Your Lordship, indeed, in the present case, the data that the counsel for the petitioner does have, it states that single women are able to freely have autonomous body decisions of her own. She is able to go and practice her profession and earn her livelihood. Your Lordship, the fact sheet also presented another crucial aspect, that Indica is a patriarchal society. And Your Lordship, as I have stated in my earlier statement, the husbands are forcing the wife into giving their consent. Your Lordships, thus the council seeks to establish a chain that states that a woman is able to practice her own bodily autonomy, and for that she should not have to ask the spousal consent. Either way, Your Lordship, even if we consider the gender neutral aspect of it, none of these spouses should have that much power that they can directly state that they cannot practice their profession, Your Lordships. Your Lordship, to further state, this is not the only contention that the council has to state that consent is being violative of sanctity. Your Lordship, coming to Article 14, we have something called as reasonable classification. Your Lordship, the courts...
Counsel, sorry to interrupt you in between. See, this court has a lot of appreciation for your emotional arguments, but do you have any information to substantiate your argument? Because all arguments, what this court feels is that based upon your conjectures. And conjectures and arguments based thereon do not empower us to declare particular provision or law unconstitutional.
Indeed. Your Lordships, the data that the council currently has is the benefits that the Act could provide. Your Lordship, the data that is provided states that the rape cases have decreased, the sexual harassment cases have decreased, the spread of sexually transmitted diseases have decreased. The government has been able to generate revenue from it since the practice is taxable, Your Lordships. Thus, there are various benefits that outweigh such considerations, Your Lordships. Further, Your Lordship, coming to my contention that Article 14 possesses a crucial criteria which says reasonable classification. Your Lordship, consent in the present case as is prevalent is only asked from the spouse of the sex worker. Your Lordship, the classification, the courts have stated that the classification should be on people who are of the same class. Your Lordships, even if it is presumed that prostitutes are on a different level as that of other people. However, the spouses of the same are not at a different footing, Your Lordships. To state that only one spouse has to ask for consent and the other who is availing the services does not have to consent, Your Lordship, does not satisfy the test of reasonable classification that has been laid down. Thus, Your Lordships, the council...
They are doing different class only, no? One is the person who is for the money, doing that, another one is for whatever reason. They are different class. It is not that within the class they have made the class. They are two different classes. Where is unreasonableness?
Your Lordships, the council might not have been able to prove her point correctly. Your Lordship, the council means to state there are two persons here. There is the spouse of the sex worker, reliance placed on the spouse, and there is a spouse of the person who's availed the services. The spouses in the present case, Your Lordship, are on the same footing. The Lordship, the council is not talking about the prostitutes, Your Lordship, the commercial sex workers, that is. Thus, Your Lordship, my only contention being that the consent of only one party is realized. Now, Your Lordship, if we were to assume that the other party who's availing the services, shouldn't his spouse, if he is married or is she married, shouldn't they also consent to the same? Should their spouses be allowed to practice or throw the sanctity of the marriage away merely because the Act only asks for consent of the spouse of the sex worker and not that of the other person who avails the services, Your Lordship? Thus, Your Lordship, the council contends that it is discriminatory and there is no reasonable nexus for the same. Your Lordship, if Your Lordship's permission, the council would seek to address the third issue, Your Lordship. Now, Your Lordship, to go, the first two issues that have been raised by my co-counsel and myself, Your Lordship, cumulatively lead to something which is most pertinent, that is the constitutionality of the Act itself. Your Lordship, when we speak about constitutionality, we presume that the fundamental rights had to be violated for your Honourable Court's jurisdiction to strike it down. Your Lordships, in the present case, there is such an instant or grave need why such act needs to be violated. Your Lordships, there are certain sections apart from Section 3 as well. Your Lordship, to guide your attention towards the same, Section 5 of the Act, which talks about license, Your Lordships.
The court would like to know from the counsel that what are the fundamental rights which you feel that they are going to be violated by this legislation?
Indeed, Your Lordships. Your Lordship, in the present case, Article 14 has been violated, Article 19 and Article 21 has been violated, Your Lordships. And further, just to substantiate this contention, Council also draw attention to Article 13(2), which states that the state shall not make any such acts which abridges the fundamental rights, Your Lordships. My Lordships, I will brief, while the course of the arguments, I will prove to this court how each fundamental right is being violated in the present case. Your Lordship, coming to the most important, one of the most facets of fundamental rights being Article 14. Your Lordships, various courts in the precedents have stated that there is always a presumption of constitutionality in favor of legislation. However, Your Lordship, it is not absolute. The right comes within its own self. The court has never stated that a state has unfettered right to impose any restriction that is possible. Your Lordship, to further back my argument, I do have a case law to substantiate. Namely, if Your Lordship would refer to page... If Your Lordship would... the Council would like to tender a copy.
Yeah, before we proceed further, your argument based upon Article 14, 19, 21, the court would like to request you to look at 19.2 also along with 19 and 21, the latter part, procedure established by law. So already Parliament has a cushion given there to put some restrictions, and Parliament has power to put these restrictions. How can you forget that part of provisions to assail on particular statute or provision thereof?
Indeed. Your Lordships, coming to the contentions, the Council humbly submits that the restrictions that the Honourable Lordships have stated, namely Article 19, subclause 6, that deals with reasonable restriction pertaining to profession, and Your Lordships, Article 21, the latter part of which deals with except procedure established by law. Your Lordship, in the instant case, these are not reasonable. Your Lordship, the courts have also held that they have to classify the test of reasonability in order for the same to be constituted, to be held constitutional. Your Lordship, the Council merely means to contend that the same are not reasonable and hence they are violative. The Council is nowhere contending that the state has no power to impose restriction. Council merely states that the restriction in the present case are not reasonable, are arbitrary and have been unexplained, thus leaving room for conjectures within the Act. And Your Lordship, if the Act remains has garnered such unfettered power, it would lead to greater consequences later. Your Lordship, coming to...
But reasonability has to be seen in the context of, in the light of the purpose of a legislation. Purpose of legislation here is to regulate the prostitution, which was century-old situation, is it not? It's only regulation and maintaining health of the sex workers and to keep them away from public places. Now, the reasonability has to be assessed on these grounds. How are you going to convince the court?
Indeed. Your Lordships, in the present case, the Council will divert your attention to the preamble of the Act. It states that the Act has been made to destigmatize it and destigmatize the Act. And Your Lordship, just the mere perusal of the preamble would further highlight that it also talks about the social stigma attached to the work are removed to the fringes of the society, deprived of the right to live with dignity and practice commercial as a profession. Your Lordship, the Act in one way states that they recognize that the commercial sex workers have been isolated from society. The public do not consider them with dignity. And Your Lordship, the restriction that have been placed to them impose the same restriction. It contradicts them, Your Lordship. Your Lordship, to substantiate the same, Section 6, 7 and 8 cumulatively state that a prostitute, they regulate the timings of the Lordship. However, Your Lordship, it does not regulate the time. It controls the time, Your Lordship. It states that the commercial sex worker can practice only after 7 p.m., Your Lordship. However, no reasonable explanation is given to attest the same. Your Lordship, to further substantiate this contention, Council would like to reiterate something that is supreme, that even the courts have held. where a legislature cannot just merely state an act to be constitutional on the basis that there is some undisclosed reason why they have enacted the acts, Your Lordship. Your Lordship, this has been reiterated in the case. This has been reiterated in the case of Chiranjit Lal Chaudhary versus Union of India. Your Lordship, this was a Supreme Court case in 1950. It stated if there must be yet to carry that presumption under Article 14. If Your Lordship could peruse page 24.14 of the memorial. It states, while good faith and a knowledge of existing condition on the part of a legislature was to be presumed, yet to carry that presumption to the extent of always holding that there must be some undisclosed and unknown reason for subjecting certain individuals or corporation to hostile and discriminating legislation was to make the protecting clause a mere rope of sand, Your Lordships, and in no matter restraining state action. Your Lordship, this has been also further been reiterated in the same case, in the case of Ramakrishna Dalmia versus Justice Tendulkar, Your Lordships. However, the contention that the council seeks to make is the reasons that have been, the sections that have been put forward in this act nowhere states why such reasonable restrictions have been added, Your Lordships.
For that, the court would like to draw your attention to preamble to the act itself, unnumbered clause 2 and 3, which very specifically states the objects behind this regulation.
Indeed. Your Lordship, even though the Act does talk about regulation, Your Lordships, however, when we look at the provisions in its entirety, Your Lordship could kindly peruse through Section 5 of the same Act, which talks of revocation of license, Your Lordship. Your Lordship, that the Act intent was to regulate and not restrict the commercial workers in its entirety. It has placed some restrictions, namely the time of work, Your Lordships. The time of work is a very pertinent factor in the present case. Your Lordship, it has been stated they cannot work before 7 p.m. Your Lordship, it would also hinder their right to earn. Your Lordship, what is the guarantee? There is no data that has been provided that could state that the majority of sex work happens in the night or even in the early morning, Your Lordship. Thus, the present restriction does not have a reasonable backing to it, Your Lordship. And hence, Your Lordship, it does not stand the test of reasonability that to hold that the Act is constitutional. Coming to Section 5 of the Act, Your Lordship, it talks about license. It talks about cancellation of license, Your Lordships. Now, it states that the license issued under Section 3, Subclause 3 to commercial sexual workers shall be revoked or cancelled if any act in contravention of Chapter 3 of the Act is performed by the commercial sex worker. Your Lordship, however, it is to be construed that it does not it provides an arbitrary power to an authority to further revoke a license. Your Lordship, there is no procedure or safeguard that states that a person whose license is to be cancelled has an opportunity to be heard in the matter. Your Lordships, the Lordships may be able to interpret the same. However, Lordship, the Act does not overtly state any such matter. Your Lordship, if he were to take a commercial sex worker whose license to be revoked, the authority suspects he has contravened any subclause Section 3. However, Your Lordship, it does not state that licensee has a power to at least have his case heard before the authority who is going to revoke the license, Your Lordship. Thus, the principles of natural justice, which states that at least there has to be opportunity to be heard, is not followed in the present case, Your Lordship. It confers arbitrary power. Your Lordship, the Council has just provided you with the case of Dr. Swami Subramanian, a page of it, Your Lordship. It's a small excerpt of the entire judgment. The entire judgment talks about the presumption to constitutionality is not always correct. It can be rebutted on two grounds, Your Lordships. The two grounds that have been stated is discrimination based on impermissible or invalid classification. Your Lordship, the Council has reiterated the consent part of it as well, whereas only one party has been unreasonably classified compared to the spouses of the same. Your Lordship, coming to the second point, which states that there is excessive delegation of powers. Your Lordship, in the present case, in Section 5, when the same is not, there is no power that checks the excessive or that the authority could misuse. Your Lordship, it does not further satisfy ground 2 as well of the conditions laid. Thus, Your Lordship, on the ground of Article 14 alone, the Council contends that the Act cannot be held to be unconstitutional. However, Your Lordship, the Council is not merely restricted to Article 14. There are two more articles that the Council seeks to contend, namely Article 19(1)(g) and Article 21 of the Constitution itself. Your Lordships, in the present case, Article 9(1)(g) postulates that postulates that any person has freedom to practice his profession. However, as your lordships have correctly pointed out, that the right is not absolute. It has some fetters to it in the form of Article 19, subclause 6 of the Constitution, your lordships. However, it states that only in the interest of general public or in the interest of general public can the act said to be reasonable. Your lordships, in the instant case, medical examination, like my co-counsel has reiterated, is only considered of one party. Your lordship, there also exists another scenario which states that a person who is availing the services might already have some sexually transmitted diseases, and the sex worker who already has undergone the medical examination might be completely unaware of the same and might, through the person, contract the disease. Your lordship, it has to be pertinent to note that Section 3 mandates that if a person who seeks for registration does not qualify the medical examination, he or she cannot practice his profession. Thus, your lordship, in the instant case, it would directly affect the right to profess their practice, your lordships, for no fault of their own, your lordships, the council might argue. Further, your lordships, the courts have also held in various cases that, the Article 21 within itself also encompasses the right to livelihood and the right to work, your lordships. However, in the instant case, the restrictions that have been placed by Section 6, 7 and 8 do not classify that as, your lordship. The reasonability of the behind the same has not been established. They have stated that the sex worker cannot practice in public places, residential places or any such places, your lordship. However, there is no mandate which states that where can the sex worker actually practice if not these places, your lordships. However, these are all open to interpretation, your lordships. Further, your lordships, in the case, your lordship, in the case of Chintaman Rao versus State of Madhya Pradesh, your lordship, again, this is a Supreme Court judgment. It states the word reasonable implies. If your lordship could peruse page 23.11 of the memorial, your lordships. The word reasonable implies intelligent care and deliberation. That is the choice of a course which reason dictates. Legislation which arbitrarily or excessively invades a right cannot be said to contain the quality of reasonableness, your lordship. Your lordship, in the present case, when none of the sections have been classified as to why they are reasonable, it cannot be held that such restriction can be reasonable or even upheld the constitutionality of the act, your lordships. The Constitutional Act in the present case is, thus the council prays that the act be struck down, your lordship. It has various lacunae in the act. Merely by severing Section 3, your lordship, would not establish the same. Section 3 of the act connects with Section 17 of the act, which states rescue of a such place.
Information given by a police officer.
Indeed, your lordship, however, the police officer can only rescue the person if they have the information, if the Section 3 of the Act provides them the information regarding the place of residence or the place where such sex worker lives. That is only enlisted in Section 3 of the Act, your lordship. Thus, when we state that a person has to be rescued, it also has to be implied that such information has been garnered by Section 3. The police, even if had to suspect, would only do so if they know that the person is situated in a certain place, which has been provided by Section 3, which provided such information has to be given. Your lordship, thus the council submits that all these acts are dependent on each other. The penalties for the same are also in respect to Section 5, 6 and 7. Thus, your lordship, there are various sections of the act. Your lordship, council seeks extension of 1 minute to sum up the arguments. Your lordship, thus the council contends that it's not just merely one section that has been challenged. The constitutionality of various sections are challenged, but are dependent on each other. Your lordship, thus in the instant case, if the entire act has to be struck down in order to safeguard the health, public safety and morality of the sex workers as well as the general public at large, your lordships. Thus, the council humbly submits that the honourable court pay heed to all these factors, your lordships.
Before you end up your argument, the court would like to remind you that this court has declared that what we have to take into account is constitutional morality, not the public morality. So, in that case, how would you argue that this court would struck down this legislation simply on public morality, forgetting the constitutional morality?
Your lordships, in the present case, from what the council understands of constitutional morality, it also states within itself that constitutional morality also guarantees certain minimum basic rights to a person, your lordships. However, in the instant case, there is a precedent that the court has stated that that any act which is on the ground of immorality has to be also be considered, or if such act is opposed to morality, the court is liable to strike it down, your lordships. Thus, in the instant case, the council argues that morality is a factor that has to be considered. The morality is a factor that has to be considered while interpreting the act in itself, your lordship. Both the social morality as well and the constitutional morality. Your lordship, there cannot be one right superseding the other. There has to be a harmonious interpretation of both, your lordships. In the instant case, both the moralities are being affected, your lordships.
That is what exactly this act intend to do. Balancing, that is what the parliament wants to do, this one. Then where is the objection then?
Indeed, your lordship, the council contends that the state has failed to balance both the rights, your lordships. They have totally taken consideration they have taken the consideration that the act has to be created for the benefit of sex worker. Your lordship, however, while doing so, they have not regulated the act, the conduct of the sex workers or their profession. They have imposed unreasonable restriction and tried to control the profession, your lordship. Hence, it cannot be said that they have considered constitutional morality as well in this aspect. Your lordship, coming to the point of societal morality, which the council would submit. In the present case, Indica has stated that marriage is one of the important facets in Indica. The committed to one's partner is also an important aspect of it. Your lordship, in the instant case, the act completely contradicts the same, and thus both these moralities are not being established in the present case, lordship, and thus to state that the state has considered constitutional morality would be wrong, your lordships. Thus, your lordship, the council humbly submits the contention and would seek permission to begin with the prayer. Indeed. Whereof, in the lights of facts stated, issues raised, arguments advanced, and authorities cited, the petitioners humbly pray for this honourable court that may be pleased to adjudge that Section 3 of the Act is violated to right of privacy, the requirement of spousal consent violates the sanctity of marriage, and your lordship, the most important prayer of us all, to hold the entire Act unconstitutional and to strike it down. And your lordships may pass any other order or judgment as this honourable court may deem fit in the interest of justice, equity, fairness, and good conscience. For this act of kindness, the petitioners shall be duty bound forever pray. Much obliged for this honourable court's time, your lordships.
Yeah, out of these three prayers, if the court accepts your third prayer, and first prayer becomes redundant.
Indeed, your lordship, if the honourable court does accept the third prayer of the council, which states that the act be struck down and be held unconstitutional, yes, your lordship, it would be connected to the first two issues inadvertently, because the third issue cumulatively deals with both the issues, your lordships.
No, what your prayer indicates that this court has to pay much more attention to Section 3 rather than the whole act.
Indeed, your lordship, it places relevance of Section 3 while drawing importance on it, because Section 3 connects to various other sections of the Act, your lordship. Hence the intent behind putting Section 3 as the important factor, your lordship. It does not mean that the other sections shouldn't be considered. It merely means that the Section 3 connects to various other sections, and hence it's your lordship, it appears that it places a domino effect. If Section 3 is said to be violated, there are various other sections of the Act which will also be declared void, your lordships. Thus, your council humbly submits the contention. Much obliged for this court's time.
Greetings through the bench. The council seeks permission to address the bench collectively as your lordships. Much obliged. The council for respondent would seek permission to proceed with statement of jurisdiction, your lordship. The respondent, that is Tree of Life NGO, has filed an intervening application under Order 1, Rule 8A of CPC 1908 as a response to the petition filed by the petitioner Astitwa under Article 32(1) of Constitution of Indica. Order 1, Rule 8A of Civil Procedure Code 1908 reads, Power of court to permit a person or body of person to present opinion or to take part in the proceedings, which is directly and substantially an issue in the suit, and that is necessary in public interest to allow that person or body of persons to present his opinion on the question of law, Your Lordship. The council further seeks permission to address issue 2. As the maintainability aspect has not been put forward by the petitioners. Issue 2 being, Your Lordship, whether Section 3 of the Indica Commercial Sex Workers Protection and Regulation Act 2021.
Madam Counsel, the court would like to know, you are representing whom?
The council is representing the respondent, that is Tree of Life, Your Lordship.
That is NGO.
An NGO that has filed an intervening application, Your Lordship. Your Lordship, the Section 3 of the Act states registration of commercial sex workers. The council would reiterate each and every clause that is given under the specific provision. Every commercial sex worker shall send the district magistrate of local area concerned an application in a prescribed form together with such fees as may be prescribed, containing 1. The name of the commercial sex worker and the manager, if any, the postal address of the commercial sex worker, the proof of age and declination of being an adult, Your Lordship, the place of performance of commercial sexual activities, a declaration to that effect of not practicing a commercial sex practice near a public place, certificate of fitness from the registered medical practitioner under Section 5 of the Act, written consent of the spouse in case of only being married. 6. Such other particulars as may be prescribed. As coming to the address of right to privacy, it is the basic nature and the general nature of the information that has been collected, Your Lordship, to maintain a record of the effect for better regulation and protection of the sex workers. That is the objective of the legislation, Your Lordship. And details are necessary and thereby have been mandated only for the purpose of obtaining a license, Your Lordship. Talking about right to privacy and its scope of operation as a fundamental right, the council would like to humbly put forward before the court that right to privacy is of a delicate nature, Your Lordship. The right to privacy by itself has not been identified under Constitution. It is too broad and moralistic to define it judicially, Your Lordship. Whether reiterating the case of People's Union for Civil Liberties versus Union of India and other, 1997, it has been rightly stated that whether right to privacy can be claimed or has been infringed in a given case would depend on the facts of each case, Your Lordship. And before ascertaining whether there is an infringement of right being contended, it has to be properly looked into the reason for which such data has been collected, Your Lordship. And in reference to the three-pronged test that has been provided by Justice D.Y. Chandrachud in the judgment of K.S. Puttaswamy and another versus Union of Indica 2017, the acceptable limits of invasion of privacy has been reiterated. The three-pronged test states that a valid law established by due procedure must exist that justifies the privacy infringement. That is, Your Lordship, if the instant matter concerning the legislation of commercial sex workers, protection and regulation is enacted by the legislature of Indica, a genuine need for the invasion of privacy must be present. And the ambit of reasonableness. This is a crucial act for prevention of arbitrary state action, and in the instant matter, the need for this act arises due to the exploitation and harassment generally faced by the sex workers. And Your Lordship, to bring a notice, this is a gender-neutral law. It does not talk only about the women, but also includes the vulnerable community, that is the LGBTQ community and the trans community, Your Lordship. And generally, these people are facing exploitation and have been, according to the facts, they have come forward to propose the need of such legislation, Your Lordship. And the third prong test says that the method, nature and quality of encroachment adopted by the legislature must be proportional to the objects, needs and purposes sought to the fulfilled by the law, Your Lordship. Such information is generally in all the fields of employment, only for the purpose of license. Even the driving license that is being obtained by a person has to provide certain personal information in order to provide such license, Your Lordship.
Please enlighten us relating to the data what you are collecting. Center is collecting data on the applicant.
Yes, Your
You
Lordship.
are making available in the RTA. This is one thing. There is no safeguard for the data. So what is the position of the candidate who has made applications? He will not be able to walk on the streets. Everybody, you are putting a tag on her, saying that she is a sex worker, do whatever you want. It is not a, what is the reasonableness in all these things? And there is no safeguard for this data. There is no mechanism in the Act. Anybody can take.
Your Lordship, this is a concern of worry, but the government is working on to provide certain rules for the accessibility of the data and the collection mechanism of the data. That has not been expressly mentioned in the Act as it is a recent legislation, but it is a concern of worry that would be taken into consideration by the government.
Then it is a manifestly arbitrary, no? It is manifestly arbitrary. No ground is required. On the seeing itself, it shows that it violates Article 21 of the either a sex worker or the whoever taking the license.
If data is going to be made available to everyone who makes an application that pays the fees, then where is the right to privacy maintained there?
Your Lordship,
Now, the other question is that you are saying that government is working on safeguarding this data, but if you look at the provisions of this Act, which says that Section 3 will come into force immediately. Now, what is the guarantee that damage which is being caused between this time?
Your Lordship, the sole objective of the Act, the legislation passed, is to solely protect the voluntary sex workers. Only if they are volunteering in such provision.
The court is talking about the data protection. You said the government is working on means and ways to protect the data. But at the same time, this legislation very categorically states Section 3 will come into force immediately. And Section 3, Clause 3 of Section 3 makes this provision, making this data available to anyone who makes an application on payment of fees.
Your Lordship, the authority that has been stated under the legislation, it is for the benefit of the sex workers, for instance, to know if they have a chronic disease or the sole objective is to prevent the same. And the authorities will ask for the statement of reason.
No, we are not saying that you don't collect the data. Yes, it is permissible. You collect the data. You are collecting for the license, ration card, everything. But how you will protect that? It is your duty to protect that data. You can't give in a RTI 50 rupees a person give demand drafts, you give all the particulars. What happens to the society? Person who does not want to, this also it will be in public market. It is moral of the society will go down. Health of the society will go down.
Your Lordship, the morality and health aspect, we do have a contention for that. The co-counsel would address the same in the further issues. But to bring in the notice...
Madam Constable, this data is not like any other data. It is a sensitive data. It brings social stigma along with that one. It is not a simple data.
Your Lordship, in any profession that is being recognized in the Indian society, certain basic required details are to be collected by any employer. And we'll work on the rules, Your Lordship, further, but then in the instant matter, when right to privacy is concerned, only the basic details are obtained, Your Lordship, and not the sensitive information. It further provides the district magistrate the authority to check whether such information is not being misused, Your Lordship. And public health supersedes individual welfare, Your Lordship. The sole objective and the purpose of the legislation is to commercialize and regularize the profession and give it an recognition in the society, because it has been prevalent through time immemorial from the Devadasi system, Your Lordship. Hence, the sole object and purpose was based on the need as per the facts.
The court doesn't have reservation about that. The court has reservation about the safeguarding that sensitive data.
Your Lordship, the counsel pleads ignorance. The counsel would address it further. It is a concern of worry, but rules and amendments can be brought. Striking down would not be a solution to the same. The council further seeks permission for the co-council to come and address the second and third issue.
Your Lordship, the Council would now address second and third issue. The second issue is whether the requirement of spousal consent violates the sanctity of marriage as espoused by the Indican society and morality. It is humbly submitted before the Honorable Court that it does not violate the sanctity of marriage, and neither does this provision go against the Indican societal values and morality. Society is evolutionary in nature, it's not stagnant, and that's why with the passing time it should be accepted in the society. With the change in the society, some certain changes that are needed should be accepted. And marriage in the earlier times was given a pious status, but now it is as opposed to it, now some people just see it as a customary practice and do not even want to engage in the same. Marriage has been a patriarchal institution, and here the faithfulness and loyalty of the women is always put to test, but it is not expected from the husband. As rightly stated by Justice Deepak Mishra in the case of Joseph Shine versus Union of India, husband is not the master of the woman. Also, sanctity of marriage, as discussed in the case of Joseph Shine versus Union of India, it was observed that people these days have live-in relationships, open marriages, and thus the concept of sanctity of marriage has itself changed in the modern times. Therefore, having this reason, as Section 497 of IPC was decriminalized, it is of course a ground for divorce, but it is not criminalized anymore. The concept of sanctity is itself not defined by the petitioner. What is sanctity here? And
if the court has accepted in past also, the sexual autonomy is there. Private spaces has to be preserved. If private space has to be preserved, then why is it necessary to seek consent of other spouse when someone wants to enter into commercial sex?
Your Lordship, to answer your question, there has been many instances where women are forced. This is the worry recognized by government while enacting this legislation, and it is more beneficial if the spousal consent is taken. It is a social construction. Although people have individual in today's era, as rightly given in the council would cite the case further for the individual autonomy, but it is rather so partners have conjugal rights. They surrender certain rights to each other while they're married, rather than saying that people have autonomy, which is rightly put forward by your Lordship. It is a social construction to maintain the stability between the partners.
If there is any misrepresentation, fraud, coercion, or husband himself will sign the wife's, majority of our population is illiterate. It is not in Delhi in one Joseph's case you have said. There is a very, very, very meaningless population. They may be having such kind of practice that live in relation and all these things. Our country is not like that. It is the institution of marriage is the basis. And there is a moral of our country. That is a social moral and also the constitutional moral. You are directly hitting on those principles. A consent, husband, a educated husband or the agents in between, they will say that, this is wife's signature. Even they are thumb illiterates. What mechanism is there under your law to punish him for such acts?
Your Lordship, general principles of contract would be applied there. The test would be applied there for contracts and compendium.
Where is the penal provision? Contract you will enforce for the damages. What about the punishment?
Your Lordship, there
No,
has.
so this part of the legislation is bad.
Your Lordship, to answer your question, please see flag 17 of the compendium, which provides with the study that 70% of the people who practice prostitution in our Indian society do it voluntarily. There has been a study provided. If you could please check flag 17. There is a survey provided. For the rest of the 30%, of course, as mentioned by the co-counsel for the respondent, there has been a worry recognized. For that, 70% of the population cannot be just neglected. For that, changes can be made by the legislation.
No,
This worry has been...
Counsel, you are not convinced the court about the requirement of consent of another spouse. The spouse is grown up, adult,
Yes.
having sexual autonomy or freedom. Why do you insist that spouse has to consent before other spouse wants to go for commercial sex? That is a question which court has.
Your Lordship, as stated earlier, the answer that was about the social construction of the society to maintain stability between the partners and to maintain transparency between the partners as they submit certain rights, surrender certain rights to each other is the contention of the counsel for the respondent. If the court is still not satisfied with the answer, the counsel seeks permission to get back to this question later in the arguments. As stated earlier, sanctity of marriage is in itself very ambiguous and inconspicuous term. And even when the intention of legislature had to be seen before, that was section 497 of IPC, which spoke about the adultery. Although it's a dead law now, the intention of the legislature that had to be seen was not to preserve the sanctity of marriage. It was only adultery if the man had a sexual intercourse with the wife of another man without the consent of that woman's husband, but the women on the other hand had no recourse. So where was the concept of sanctity of marriage then?
The court would like to remind the counsel that 497 declared unconstitutional not based upon this contention. It's based upon the contention of violation of Article 14 and 21.
Yes,
Not
sir.
based upon the sanctity of marriage or anything else.
Your Lordship, the counsel is putting forward for the persuasive value to know what is exactly sanctity of marriage. It is very ambiguous, is what the counsel is trying to put forward.
Do you feel that a sensible husband or a wife, as the case may be, would really put a pressure on the other spouse to go for commercial sex, even he or she wants to keep that marriage and institution intact? Do you really think that this is possible? Or it's only a kind of imaginative argument?
Your Lordship, as given by the statistics, that is 70% of the people practice prostitution according to their wishes. There might be a chance where it can be forced by the husband and wife, and for that certain amendments and rules can be brought into the legislation, but striking it down itself is not a valid solution. And there is an individual autonomy given to the persons in today's era. They can do whatever they want with their bodies, is what the contention of the counsel is. Yes, Your Lord. Yes, Your Lordship. That the society is not stagnant in nature. Yes, Your Lordship.
That this court has time and again emphasized there's a private space where legislature cannot enter. The private space. Private space is given to individuals
Yes, Your Lordship.
where legislature is not allowed to penetrate. Now this act is trying to do that one.
With
How
the
do you justify this one?
with voluntariness, with free will. So if the
See, there is no free will. See the contradictions in your arguments. On one hand, you are pleading for free will, and now other hand, you are pleading for coercion from the other spouse.
Your Lordship, the council is not pleading for coercion from the other spouse. The council is rather pleading that in the patriarchal society that Indican society has had before, the sanctity of marriage was never taken into consideration. So what is the sanctity of marriage here? The question is, what is the sanctity of marriage, and not the pleading that there can be coercion.
Marriage goes to the domain of moral law. We are sitting here in the judgment of man-made law.
For
Now,
moral,
how do you expect this court to extend that moral argument to a legal argument, convert it into legal argument, and struck down the legislation?
Your Lordship, with that, there is a case about the morality question of Gherulal Parak versus Mahadevdas Maya and others. It's a Supreme Court case. If you could please check flag 10 of the compendium, page number 7, and compendium flag number 10. Here it was mentioned that morality is varying content depends upon time, place and stage of civilization of a particular society. So when it is clearly observed by the Supreme Court of Indica, there no question of morality comes in this picture. And as also stated by Justice Nariman in the case of Joseph Shine versus Union of India, we always had the concepts of polyandry and polygamy. For flag 7 of the compendium. It's highlighted in flag 7. We've always had the concepts of polyandry and polygamy in the society of Indica before. Where was the concept of sanctity of marriage then, as rightly observed by Justice Nariman in the case of Joseph Shine versus Union of India? It has been highlighted. If the court is satisfied with this issue, the council seeks permission to move with issue 4. Issue 4. Whether the Indica Commercial Sex Workers Protection and Regulation Act 2021 is against public health, safety and morality and is liable to be struck down. It is humbly submitted before the Honorable Court that this particular legislation is not against the public health, safety and morality. Living in this new era of constitutional interpretations, the judiciary has relentlessly interpreted constitutional provisions in a way which echoes principles of individual autonomy and freedom, debating on the validity of the Indica Commercial Sex Protection and Regulation Act 2021. The first issue that is there is about the public health. There has been reduction in the sexually transmitted diseases. According to the NCRB report, at the national level, estimated adult HIV prevalence 15 to 49 years has declined since the epidemic's peak in 2000, where prevalence was estimated at 0.55 in 2000 through to 0.32 in 2010 and 0.21 in 2021 is when the legislation was passed. Section 3, subsection 1, clause 5 of the Indica Commercial Sex Workers makes it mandatory for medical assessment before granting the license, making sure that there are no chronic diseases to the persons before they get into this particular profession. And hence, it is very much evident that this particular legislation is not against the public health. The second concern is about public safety. It is very much clearly stated in the facts itself that the cases of rape and sexual assault in the past 3 months, as per crime ratio reports, has gone down. And with this particular fact, the council puts forward the Honorable Court that this particular legislation is not against public safety. Rather, it is safer for the general public and also for all those involved in the trade. The third concern, that is about public morality. The world has accepted the ideology which is very much inclusive in this in today's era, and this inclusivity also has the choice of profession with dignity in that case, which is the very objective of this act if seen in the objectives of the act. And standing in this day and age when there is hue and cry about individual autonomy of the persons and live and let live, saying that this liberal act should be struck down is very regressive in nature and very irrational. The concern that people have while stating that prostitution should not be legalized is that women who get into this profession will not be able to come out and teach young girls that their bodies are for the sole purpose of exploitation by men. But as stated in the case that was cited before the Honorable Court earlier, that was Gherulal Parak and Mahadev Das Maya, it takes in every aspect of personal conduct deviating from the standard norms of life. It may also be said what is repugnant to good conscience is immoral. Its varying content depends upon place, time and stage of civilization of a particular society. And because the position of the society has changed now, it has become more acceptable and more inclusive in nature. The ideologies the society has accepted in today's time, the narratives has changed. There should be no question of morality in itself. Legalizing prostitution has had various advantages for the countries who have already legalized it. For instance, Netherlands. Netherlands took this particular profession out of the black market, and strict regulation of laws, which is again the very intention of this legislation as well, has given protection to the people who's been practicing this particular trade. Because of this, protection was given, and the revenue of the country also showed a positive inclination, which is also given in positive incline, which is also given in the facts of this particular case, that because of this particular legislation, the country was able to earn more revenue. Your Lordship, as given in the facts that rape cases and sexual... No, Your Lordship. As the current issue is talking about public morality, the council wanted to bring into the notice of the court that the question of morality that was put forward before was clearly given that morality in today's time has changed. And rape cases and assault cases, which was a concern again in this issue.
Let me remind you that this court has very assertively stated in number of cases that this court is concerned about constitutional morality articulated in preamble to the Constitution, Article 14 and Article 21. The court is not concerned about or bothered about public morality as such when it comes to declaring particular legislation unconstitutional or constitutional.
Your Lordship, council is pleading that the very purpose of this particular argument is that, for example, if you could please check flag 18, which states about the New Zealand Act, which has a very similar legislation, has been very successful in protecting people who have been practicing this particular trade. And the benefits of similar acts was the very purpose of this argument. We also have your Lord. Your Lordship, but the country of Indica has also recognized constitutionalism. If you could see the flag, there it is written constitutionalism. There has to be some steps taken for transforming the society, politically and societal structure. It is the very first step to transforming the society, as the country has recognized constitutionalism.
Yeah, the court would like to know from you that what kind of safeguards for putting data is mentioned in this act.
Your Lordship, for that, but to answer your question, for that, the country of Indica also has IT Act, which talks about data privacy.
No, Council, our concern is that protection of vulnerable data. As the court has said earlier, this data is not data per se. It is sensitive data because it involves social stigma. And by virtue of any of the provisions of this act, anyone who can put an application that pays the prescribed fees is entitled to seek the information. Now you are referring to a New Zealand legislation. Do you find any kind of mechanism which is being articulated in that legislation to protect this kind of sensitive information? That is our concern.
Your Lordship, to answer your question, there has to be a statement, although the Act is silent on it, this particular legislation is silent on it, the authorities who will be publishing this data will not just publish it. There has to be a statement of reason, and it will be more beneficial for the sex workers itself. Because what if they have chronic diseases? The prevention of spread of the same can be...
Council, you are reading the legislation. You are reading the legislation to suit your convenience. If you go by the provision of the Act, it nowhere states. It simply says that anyone who makes an application and pays the fees, he is entitled to seek the information.
Your Lordship, it is being recognized as a worry. So for that, amendments and new rules can be passed. But the greater good of the society should also be taken into consideration. Because of some worries in the particular legislation, it is not valid to strike down the entire legislation itself.
Believing your assurance that the government will come out with regulations, what is about the damage caused in between?
Your Lordship, if the court permits, the council would get back on this question in the later part.
Seek your assistance in clarifying three concerns of this court. One is inequality, on the ground of inequality. Now the court has a concern about the consent of a spouse when the spouse is married. What is about a woman who is unmarried or a man who is unmarried and wants to get involved in commercial sex? Now, don't you feel that this is a kind of discrimination between married and unmarried individual, which this court has struck down very categorically in a case, that this is a violation of Article 14? And that gives us power to strike down this legislation, or particularly Section 3. This is one. We want to seek your assistance. Second one is a procedure established by law. Now, Article 21, which you are again and again relying upon for seeking privacy, the procedure seems to this court is capricious one. The procedure is unregulated one. Lot of discretion is given to the authorities to collect the information, to arrest the persons, to de-recognize the license, and therefore this court finds that the procedure which this legislation talks about is guideless, doesn't have any guidance, and court wants to seek your assistance on this. Then coming to this protection of health, STD you said, spread of. Now here again the court finds a kind of discriminatory treatment. Now this legislation insists upon periodic medical examination of the commercial sex worker. But what about the clients? There is no provision in the legislation which insists upon the medical examination of the clients. We are equally vulnerable to spread this STD. Now here the court thinks that there is a little bit discrimination, and therefore the court wants to seek your assistance clarifying these three: inequality, procedure, and health.
Your Lordship, to answer these three concerns, consent, when we're talking about consent, the Council believes that there is no discrimination as such between married people and people who are not married. It is
It's relied upon this argument only to stuck down a provision of the criminal law. You know that.
Your Lordship, if you could.
Adultery. Because that discriminates between a married woman and unmarried woman. That is one of the considerations which this court has taken into account to stuck down a provision.
Your Lordship, but in the very same judgment, the sanctity of marriage was also given a new idea about the sanctity of marriage was given. It is simply to have stability between the partners and to have a social construction. It is rather a social construction is what council is pleading before the court. For the second concern that was given, also for the consent part, it helps in maintaining more transparency between the partners. It is an institution, it is a social institution, and hence more transparency should be maintained in the marriage. For the STDs part, the practicality should also be looked into. Every client of the people who are practicing this particular profession, it is not practical enough to check that whether these people have chronic diseases or not. What is more practical and more convenient in that case, not impossible, is that Lordship. Is that people who want to get into this profession should have themselves tested. The practicality should also be looked into. It should not be impossible for the authorities to make sure that whether they are.
In that case, you can advise your government to make a provision in the legislation that before a sex worker entertains any customer, they have to show the certificate that he doesn't carry any kind of infectious disease.
Yes, sir.
What's the harm in that?
Pardon, Your Lordship, if you could repeat the question.
Your argument is that it's going to be impracticable. Then what's the harm in putting a provision in the legislation itself that whenever a sex worker entertains a customer, she has a right to ask for a certificate that he doesn't have any kind of disease?
Yes, Your Lordship, that will be taken into consideration and necessary amendment will be made. And that's why the suggestion that has been given by the court will be implemented, and hence striking down the entire legislation will not be valid. Your Lordship, if you could please repeat the third concern the court had.
Discrimination between sex worker and unmarried woman.
Your Lordship, this particular legislation focuses on is gender neutral, as already understood by the legislation, and also focuses on the rights of transgenders. Now, of course, there is a concern that there is a discrimination, but then again, as put forward, the position married people are into and people who are not married are very different. For instance, married people share the rights. For instance, they take care of children together or have conjugal rights. In that case, it becomes more important for the married people to have transparency, is what the council is pleading before the court.
What this court observes from our argument is that you partially agree that this act is discriminatory.
Your Lordship, the council does not believe that the act is.
But the way in which arguing that is giving us impression that you, by necessary implication or in between the lines for argument, you are accepting that this act is discriminatory.
Your Lordship, the council is extremely sorry, but that's not what council is implying. Council is implying that the position of different people in different the position of different people in the society has to be looked into. It is not that it is discriminatory. The position that they are into in a particular society should be looked into. Council seeks permission for extra time to conclude the argument. So the position that they're into is very different. It is not discriminatory, it is to bring them into equal footing. In the case of Kajal Mukesh Singh and others versus State of Maharashtra, 3 women were booked under Immoral Trafficking Act in their late 20s, and the court observed that an adult woman shall have all fundamental rights to choose their occupation. Similarly, the court, through a recent judgment, which is Buddhadev Karmaskar, also held that sex workers are no less humans and thereby entitled to a life of dignity as their fundamental right. When all such issues have been already settled, the need for debate whether commercializing sex work would degrade us as a society is very irrational and is wasting the time of the court. If your Lordships are satisfied with this issue, the council seeks permission to move with the prayer. Wherefore, in light of the issues raised, authorities cited and arguments advanced, the Honorable Supreme Court of Indica be pleased to rule in favor of the following. Section 3 of the Indica Commercial Sex Workers Protection and Regulation Act 2021 is not violative of right to privacy. The requirement of spousal consent does not violate the sanctity of marriage as espoused by Indican societal values and morality. The Indica's Commercial Sex Workers Protection and Regulation Act 2021 is not against public health, safety and morality, and therefore is not liable to be struck down. Much obliged, Your Lordships.
Your Lordships, to begin with, my first contention that I have for rebuttal is that the councils in the course of their arguments have stated that morality need not be considered. Your Lordship, however, the Honorable Court in the case of Raj Bahadur versus Legal Commensurate have stated that the moral aspect of law also has to be considered when you are taking in consideration profession, Your Lordships. However, to state that moral aspect to be considered is void. Your Lordship, council would seek an explanation on the matter on how morality has to be completely excluded. My second contention, Your Lordship, would be the council have cited certain statistics of NCRB report and various other statistics which state 70 million sex workers. However, Your Lordship, the data in the present is not of that of Indica. Your Lordship, the data that has been given to Your Lordship is that of India. Your Lordship, the present case, only the laws of Indica and India paramateria to each other and not the statistics. Your Lordship, thus the statistic that the respondents have made cannot be admissible, Your Lordship. Further, Your Lordship, the data, the council's, the contention being the data that has been relied, where the rape has decreased for 3 months. Your Lordship, the benefits of the Act also have to be viewed with the negative impact that the Act has, Your Lordships. The same proposition which gives them the benefits also states that the harassment has increased, that the states have objected to it on the moral aspect of it, that marriages, a decline in the sanctity of marriages. Your Lordship, all of these points have not been balanced to say that one has to supersede over the other, Your Lordships. Further, Your Lordships, further your lordship towards the course of the argument, the main aspect of them, that is the constitutionality, why the acts are reasonable, why the certain sections are reasonable or not, have still not been covered. They have failed to mention how these restrictions that have been enabled by their act are reasonable and can come under the ambit of 19 subclause 6, your lordships, or under even article 21. Your lordship, your lordship, the council have also relied that under section 3 subclause 3, the district magistrate would imply that he would protect the data. Your lordship, it would also imply that we are placing unfettered power over an authority to decide how he decides to disclose that data or not, your lordships. Further your lordships, the medical data that has been given, they have tried to validate the argument by stating that such medical data is in the interest of general public. However, your lordship would also stigmatize the sex workers in holding that such data can be used to label them, and also some of the conservative people of society would refuse to interact with such persons whether they were aware in public domain with diseases that they have or do not have, your lordships. Further your lordships, coming to the aspect of sections, your lordship, the councils in the course of argument have failed to address certain sections, mainly all the sections of whether they are constitutional or not. Thus, your lordship, there still exist ambiguities in the act that have been unexplained, and thus, your lordship, they have not proven the keen issue whether the act is constitutional or not. Thus, your lordship, the council humbly submits their contentions.
Your lordships, the council would seek permission for sir rebuttal. The council would like to address the welfare provisions that are stated under the legislation. Section 10, your lordship, prohibits seduction or engaging in commercial sex with a minor, your lordship. Section 12 prohibits or procuring and inducing or forcing a person for the sake of engaging in commercial sexual activity. Section 14, your lordship, there is special police officer and advisory body that would help the legislation in itself to address upon these issues. Section 15, your lordship, provides duties of special police officers and other officers to govern and regulate and regularize the profession when it is taking place in the society, your lordship. And section 17 also provides the rescue of a person. So these are the welfare provisions that are provided under the legislation. Also, concerning the morality aspect, the moral grounds have been changed due to the changes in the society, and the council is not pleading that moral aspect does not exist, but the contention of the council is that the morality aspect is changing and evolving, your lordship. Hence, a progressive and prerogative legislation is the need of the hour, and is the community as a whole of sex workers, LGBTQ and trans workers have come forward to accept this as a legislation, and hence striking down completely the striking down of this legislation completely is not a solution, your lordship, because there are certain rights that are provided under the legislation in itself. It is not giving sole power to the officials, but it is also the timings that are mentioned, your lordship. If the trade is for 24 hours, there would be no authority and no regularization mechanism. That is the concept behind curfew also, your lordship. When there is a stipulated time period under which a trade is being practiced, it is easy and it is more efficient for the police officers and the advisory body to take care of certain immoral activities or involuntary sex practice that happens in the society. The prostitution the profession in itself has been prevalent in the society. The aim of this act is to regularize and protect the rights of such workers and not anything else, your lordship, and hence the striking down of the whole legislation is not the solution before the court, your lordship. Much obliged, your lordship.
Shik, 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 shik.